This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Kindly come to the Calcutta High Court Contempt of Court Rules 1975, Rule so and so, so and so, so and so. Kindly come first to Rule 2. Proceeding in connection with the civil contempt may be initiated by a petition present so and so, it is not required for us. Or by the High Court on its own motion. High Court by its own motion. What is own motion? I'll explain later on, but I think this rule is sufficient for the first category of my submissions. On a reference made to the High Court by the subordinate court as the cause of criminal contempt, proceeding in connection with the criminal contempt may be initiated A. On a motion of the High Court in respect of a contempt committed upon its own view under Section 14 of the Act, not applicable. On its own motion by the High Court under Section 15 subsection of the Act, or C. On a motion founded on a petition presented by the Advocate General under Section 15(1)(a) of the Act, and D. On a motion founded on a petition presented by any other persons with the consent in writing of the Advocate General under Section 15(1)(b) of the Act, on a reference made to the High Courts by the subordinate courts under Section so and so, so and so. There are 3 or 4 categories that thing. One of the category is that with the consent of the Advocate General. And second of the category is that court on its own motion. Contempt may be initiated on a motion. Administrative order does not reflect or cannot reflect initiation of any motion. Next. Every petition shall be expressed to be made in the special jurisdiction of this court, provided that every petition for civil contempt shall be expressed to be made in the special civil jurisdiction, and that every petition for criminal contempt in the special criminal jurisdiction. It is under the special criminal jurisdiction. Now, my lord, kindly come straightway. Rule 16. It is all petitions presented by the Advocate General and all petitions presented by any other persons under Section 15 of the Act shall be moved before the bench presided over by the Chief Justice or by such other bench as the Chief Justice may from time to time appoint. All matters relating to contempt, subordinate court, brought under so and so shall be dealt with by the bench presided over by the Chief Justice or by such other bench as the Chief Justice may from time to time. On that date, when the administrative order was passed, it was not moved before the Chief Justice. Or any other bench determined by the Chief Justice, which is called the jurisdiction. Again I read. All petitions presented by the advocate, all prescribed by any other person under Section 50 of the shall be moved before the bench presided over by the Chief Justice or by such other bench as the Chief Justice may from time to time appoint. All matters relating to contempt of so and so Chief Justice or some other bench as the Chief may from time to time. Next, rule issued by any court on its own motion shall be dealt with by the particular court, provided that such rules under Section 15 of the Act shall be heard and determined by such bench of judges as the Chief Justice may appoint. Rule issued by any court. Rule issued by any court on its own motion shall be dealt with by the particular court, provided that such rules under Section 15 of the Act shall be heard and determined by such bench of judges as the Chief Justice may appoint. 18. Notwithstanding anything contained in Rule 15 to 17 above, the Chief Justice may assign a rule. Chief Justice may assign a rule for hearing before another judge or bench if required in the special circumstances of the case, or if the judge or the bench reports to the Chief Justice for so doing. Therefore, when the Chief Justice can assign a rule. Chief Justice cannot assign a whole contempt matter to a court, contempt application. Only a rule, if the rule has been issued by the Chief Justice. No rule has been issued by the Chief Justice and thereafter it has been assigned to a lordship. And my lord, with great respect to your lordships, my lord, kindly do not take me amiss. For all arguments' sake, I will be arguing. Your lordships have no power to issue rule. If a rule has been issued and it has been assigned to your lordships can decide the matter. Therefore, when the rule was issued by your lordships, my lord, with great respect, your lordships did not have power. Maybe as a special bench.
So that's the first point.
We have to go by the rules.
Yes. So no power, no jurisdiction. Now, second point.
No rule has been issued by the Chief Justice at all. By a competent court as defined as settled by your lordship's court rules. Rule has been issued in this case by the assigned bench, which does not satisfy the requirements of Rule 15. This is my first one. This is my first
Yes,
one.
yes. We have noted. We have noted.
Shall I proceed?
Yes.
Now, very importantly, your lordships kindly come. In re suo motu proceeding by Honorable Court number 1. What is that suo motu proceeding? What do you mean by suo motu proceeding? When a rule has not been issued,
What
order,
are you?
kindly see your lordship's order. Dated 2nd May 2025.
তাও যেটা বলছেন তাও
2nd May. What is the proceeding? Tested before the bench. And on the first day it has come before a lordship's court.
second May order.
In re suo motu proceeding by the Honorable Court number 1, what he has initiated. What is can the Chief Justice in his administrative side initiate a contempt proceeding? We have 2 copies. What is that? An administrative side and an order has been passed. It doesn't mean that a judicial court has initiated a suo motu proceeding. But we have seen that.
Yes.
Now see your lordship's kindly address your lordship's order. Mr. Joyanto Mitto, senior so-and-so, for the petitioners in CRLPP number 7 of 2025. Then your lordship see so-and-so for the petitioners in CRLPC 6 of 2025. Therefore, after see Mr. Parthasarathi senior so-and-so for the petitioners in CRLPC of 2025. Then again for the petitioners so-and-so for the alleged contempt. Therefore, before your lordships, there are petitioners. If there are petitioners, how it can be a suo motu? If the petitioners are there, my lord, in that case, first is consent of the Advocate General is required to be taken.
Yes.
Now, your lordships, can you read the order, paragraph 1? These proceedings for criminal contempt have been initiated suo motu by the court of the Honorable Chief Justice. What from your lordship have got it? Not the court, but an administrative order. Then, Malaka, we have gone through the materials which have so far been brought on record, including affidavits of person, so and so. We are of the view that the criminal contempt has been committed in this case by the alleged complainants by interfering with the due administration of justice, judiciary. Your lordships have formed your lordships' opinion of committed contempt. What trial, what argument I will make? It is not that prima facie your lordships were satisfied,
Yes.
but your lordships were satisfied. We
Prima
are of the
facie.
view.
Prima facie. Sentence starts with prima facie. Please read.
We have gone through the materials which have so far been brought on record, the affidavits who are present at the place of. We are of the view that the criminal process have been committed by the interfering with the due administration.
Prima facie. It's not there in your.
Oh, yes, yes. Prima facie, sorry. Prima facie, we are of the view.
Yes, yes.
Hence notice be issued. Kindly come to next order. Again, in review of suo motu, so and so, court is on its motion, so and so, so and so, so and so.
Now, Shabi, now, work with that.
It is so.
Date of the order, next order.
Yes, the order is dated, my lord, 19 May 2025.
That আছে তো নিশ্চয়ই।
Of the Commissioner of Police be kept with the records. My lord, got it? A report filed on behalf of the Commissioner of Police be kept with the records. Affidavit filed on behalf of the Incorporated Law Society be also retained with the records. By our order dated May 2020, we had ordered recorded the prima facie. We are satisfied the Commission of Criminal Contempt. We are granted liberty to the alleged contemnants to file their replies within a fortnight from suance. Today, all the alleged contemnants are represented through learned advocate. None of them filed the affidavit. The allegations against them remain uncontroverted. There will be rule against the alleged contemnants. The rules are made returnable on January 16. Therefore, rule have been issued by your lordships. With great respect, under our contempt rules, assigned bench has no jurisdiction to issue rule.
Just for our clarification,
Yes, it is
under rule, কোথায় গেল রে বাবা? Under rule 16, 16 doesn't talk of assignment of rule. 17 says rule, 18 says rule.
all petitions, let me read it. All petitions
Yes.
presented by the Advocate General and all petitions presented by any other persons under section 15 of it shall be moved before the bench presided over by the Chief Justice or by such other bench as the Chief Justice may from time to time appoint. On the date it is alleged to be initiated. That day this bench was not existing. Let's assume Chief Justice on a usual days, Chief Justice determination has been given to a bench presided over Justice Arijit Banerjee for the content matter. I can understand Justice Orijit Banerjee sitting with Honorable Justice Sukosachi Bhattacharjee has taken up the matter. But on the day, determination was with the only Chief Justice. There was only the Chief Justice bench. Bench means court. Where is that order here?
So Banerjee
This one.
with the leave of Justice
This
Banerjee.
one.
Now here, this Rule 2A, read with Rule 17, can't it be interpreted that there is a distinction between initiation of a contempt proceeding and issuance of a rule? Suppose even in contempt applications, an application is filed, that is the initiation of a contempt proceeding. Subsequently, prima facie being satisfied, we issue a rule. Now, we are speaking against you so that you can...
Yes, my lord, yes.
Now, let us contemplate it like this. 2B empowers the High Court to initiate a contempt proceedings. Proceedings in connection with a contempt, criminal contempt also, may be initiated by the High Court of its own motion. Rule 2.2. Proceedings in connection with a criminal contempt may be initiated on a motion of the High Court in respect of a contempt. Now, proceeding is initiated by the order of the Honorable Chief Justice, barring your administrative portion, will be coming to that. Proceeding is initiated by the Honorable High Court. Then under Section 7, Rule 17, this bench issues a rule. So then Rule 17 says rules issued by any court of its own motion, proceedings initiated by the Chief Justice under 2.2, sent to us, constituted a bench, and then we issue the rule under Rule 17, and we will deal with that. Can't it be interpreted that Chief Justice only initiated the contempt proceedings, but the issue is, the rule is issued by us for the first time?
Who will initiate? A court?
Yes, Chief Justice's court.
Court.
Yes.
But here the court has not initiated.
Can't there be two components of the same order?
No.
Judicial and administrative?
No. Administrative order thoroughly, this is different. Administrative order cannot be treated as a judicial order.
The first part is that suo motu proceedings has been initiated by the chief. And the matter is the bench is assigned.
May I just,
Yes, please.
may I clear it? My understanding. Court means what? High Court means what? If you say High Court, then the High Court entire all the judges. Or Chief Justice has made a determination. If you say High Court, then High Court, all the judges have to sit and they issue the rule. Or the Chief Justice. Or determination given by the Chief Justice. Therefore, it is very clear it should be a judicial order. But that, my argument will make it very clear when I read Rule 17. Assignment is after the issuance of the rule. Make a legal, and I am arguing actually against the judicial, against a person who may be your learned brother in here, and who is practically my brother in other life.
That has got nothing
to do.
Absolutely.
But I am sorry. But,
No. We are on.
This 17 rule has not been assigned. But even if we give an effect interpretation of the Rule 2, the way my Lord Justice Bhattacharjee is making the observation, then Rule 17 has to be ignored. A statute has to be read whole, not part. second part, it will take time. Now it is 1:10.
Very well.
Next
Next Monday.
From 2 o'clock, I have matters.
Next
Give
Monday.
me some more time, not for half an hour. So
No.
that I can finish it. It is not
1 hour. 1 hour.
30 তারিখ হ্যাঁ 30 তারিখ কোনো অসুবিধা নেই
Yes.
তারিখ আমার অসুবিধা কি না না আমি থাকবো না হয়তো
Just
one request I will make, my lord. If your lordships can dispense with the appearance of the contempt.
yes.
Before your lordships do that, but just for a digression, kindly look at the penultimate paragraph of your lordship's order. Which order?
Which order?
One order,
Our order or Chief Justice's order?
your lordships. 12:30 a.m. they have been directed to appear.
They appeared.
At 12:30 a.m.
Oh, it's all right. Anyway, no.
Taking you from Mr. Bandyopadhyay's argument that it is there at 12:30 a.m. High Court doesn't see it. How can they appear?
Affidavits
I have not given
filed by the alleged contemners
mind to that extent.
in court today. Vacate with the
Normal
records.
court hour.
Stop. The personal appearance for the time of the alleged contemners is dispensed with for the timing upon their undertaking to be present as and when so directed. Paragraph, Mr. Bandyopadhyay, learned senior advocate representing the respondent number 8 in
CRLCP 7 of 25.
Hecho,
CRLCP 7 of
begins his argument. Stop. He does not conclude. Paragraph, list this matter once again on Shamne Shombare date the 30 tarikh. Marked 12:15.
12. I will finish by 1:15.
ঠিক আছে, marked
So that
12 noon.
finished it.
12 noon. ঠিক আছে. Yes, because after that we'll have to hear others.
I am not available every day. I do not want to.
We know how busy you are, Mr.
No, that different parts, different things. Tomorrow, interestingly, I will tell you, finish the order. Tomorrow, I have a meeting of law standing committee and I'm leaving today after doing another matter. Agenda, do you know the agenda? You will be annoyed with me. Agenda is ethics of the High Court judges and the Supreme Court judges.
You alternatively create the law and then challenge it before the court.
That's a different thing. Second is no post-retirement appointment. We will make it, you will strike it down. A proposal, discussion. Deep love lies to your lordships. Deep love lies.